Clause. If the clause requires an impeachment conviction first, he may not be prosecuted, but if it contains no such requirement, the clause presents no impediment to his prosecution. Former President Trump also implicitly concedes that there is no absolute bar to prosecuting assertedly, quote, official, end quote, actions. He argues elsewhere in his brief that his impeachment on the charge of inciting insurrection was based on conduct that was the, quote, same and closely related, end quote, to the, quote, official acts, end quote, charged in the indictment. Appellant's brief 4-6, quote, President Trump was impeached and acquitted by the Senate for the same and closely related conduct to that alleged in the indictment, end quote, emphasis omitted. It at 42, quote, all five types of conduct alleged in the indictment constitute official acts, end quote. And he agrees that if he had been convicted by the Senate in that impeachment trial, he would not be immune from prosecution for the, quote, official acts, end quote, at issue here. See id at 31. Thus, he concedes that a president can be prosecuted for broadly defined, quote, official acts, end quote, such as the ones alleged in the indictment, under some circumstances, i.e., following an impeachment conviction. The impeachment judgment clause is focused solely on those who are convicted by the Senate following impeachment by the House. The first part of the clause limits the penalties that can be imposed based on an impeachment conviction. Quote, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, end quote. U.S. Constitution, Article 1, 3, Clause 7. The second part makes clear that the limited consequences of impeachment do not immunize convicted officers from criminal prosecution. Quote, the party convicted shall nevertheless be liable and subject